Thank you, Mr. Speaker. Thank you, Chairman Smithee, for your work on this bill. I just wanted to flesh out, I know Representative Cook asked some specific questions, and I want to flesh this out a little bit more so that, as you know, it is true that denying somebody bail, their life and liberty, it's a very serious matter. Is that correct?
It is a very serious matter.
And we have to have some constitutional safeguards, statutory safeguards, so that we're not unjustly holding somebody or detaining somebody, taking their liberty away. And we have to have some safeguards for that. Is that correct?
It's all about a balancing, as you know, Mr. Walle. We want to keep the right people in jail and get the other people out of jail if possible.
And to that point, the right people out of jail, the bad people in jail, I get that. I just wanted to flesh out some of the specific enumerated crimes that SB 9 prohibits release for. And so right now, SB 9 prohibits release on personal bond, release without financial requirements, for defendants charged with the following offenses, even if it is their first offense. I want to start there. Even if it's their first offense, SB 9 prohibits the release on personal bond for somebody that's murder arising from the manufacture or delivery of penalty group 1B substances. Is that correct?
That's correct.
Okay. Also, somebody who's been alleged to have committed a terroristic threats chargeable as Class A misdemeanor or higher. Is that correct?
Yes, yes.
Okay. Violations of certain court orders or conditions of bond. Is that correct?
That's right.
Okay. And unlawful possession of a firearm by a felon. Is that correct?
That's correct.
Okay. It also prohibits bond for individuals on parole if they commit a felony.
Well, actually, let me correct you. It doesn't prohibit bail for those individuals, but by a personal recognizance bond. So you're going to have to post a monetary bail or bond. And it could be in really any amount set by the court. But right now, a lot of times the defendant is released on personal recognizance. And so we're trying to tighten that up a little bit for some of these more serious crimes.
Okay. So for somebody, particularly financial bail, I guess, for somebody that commits a felony, assault, deadly conduct, or disorderly conduct involving the discharge of a firearm in public or the display of a firearm or other deadly weapon in public to alarm people. Is that my understanding as well?
I think so. I think that's the way it's worded.
Okay. I just want to make those clarifications so that the public's aware of what we're doing this morning.
And I think what we're trying to do is stop this revolving door where...
I get that.
Yeah. Okay. So
yeah, no. I get that. You particularly for folks that are... But this first class, these are for folks that have committed their first offense.
Yeah.
That's my understanding. Okay.
Yes.
And then... this applies, as mentioned, to populations over 200,000. Is that my understanding?
Well, that's a different provision of the bill. That just says that in a county over 200,000, a magistrate cannot make a decision to release a defendant of committing serious crimes. It has to be a district judge that makes that decision.
So. Let me clarify that. So in counties with populations over 200,000, magistrates appointed under Chapter 54 of the Government Code may not release a defendant on bail if the defendant was, one, on bail, parole, or community supervision for a felony and is charged with a new felony. Is that correct?
That's correct.
Okay. Has two or more felony convictions resulting in TDCJ imprisonment. Is that correct?
Correct.
Okay. Is subject to an ICE detainer.
Yes.
Okay. Or is charged with murder, capital murder, aggravated kidnapping, or aggravated sexual assault. That applies to counties with populations over 200,000. Is that my understanding?
That's right.
Okay.
Now, if you're under 200,000, a magistrate can make that decision.
Okay. On that note, why would we limit why would not this provision apply statewide?
Well, that's a good question. You know, it came that way from the Senate, and there did not appear to be any good reason to change it. I would say there's two reasons. One is that most of the problems that we're seeing today with bail most of the problems are occurring in counties over 200,000.
But that doesn't mean that it doesn't happen in counties less than 200,000.
No, I've got an instance, where it's happened. I mean, I can't reveal. I mean, I can't really cite the name, but I know it's happened in a county of less than 200,000. It's much more rare. And the other issue is the available resources that are available. Like a number of rural counties in the state have no individual district judge. It's basically a circuit judge that covers
travels
counties.
Multiple counties. I understand.
And so that seemed like a logical place to break off the population was at 200,000.
Okay. I think that is a concern of mine, particularly if we're concerned about public safety. We should be concerned about rural communities that might have this issue as well. Now, you mentioned that this seems to be more prevalent. There's a lot of media coverage, and rightfully so, in very egregious evildoers that do this repeated offense. We want to hold those folks accountable. I get that. I guess my concern would be if it applies, for my county and Harris County, it should apply for a rural community as well if that's happening in a rural community. Because I'm concerned about the victims of crimes in Harris County just as equally I would in a rural community, in your community, in the Panhandle or West Texas. That's my only concern with this provision of the bill, is it applying statewide. And we'll come back to that point.
Okay.
Let me also flesh out. I know Representative Little talked about the appeals portion of the pretrial detention. So SB 9 allows prosecutors to appeal bail amounts they consider insufficient for certain serious offenses or felony offenses committed while on bail for another felony offense. Is that my understanding of the bill?
Right.
Okay. Defendants who are already in custody must remain incarcerated during the appeal. Is that my understanding?
That's correct. Up to 20 days.
Up to 20 days. And I was going to get to that. The Texas Supreme Court must adopt rules for expedited appeal procedures for bail in which rulings must be issued within those 20 days. Is that my understanding?
Right.
Okay. And then so a district judge, either in a county where the defendant is being tried or where the felony charge will be filed, may modify a bail decision made by a magistrate of a court without jurisdiction over the offense, regardless of whether the formal charges have been filed. Is that my understanding of the bill as well?
I think that's the language in the bill, yes.
Okay. The local administrative judge must create a procedure for district clerks to notify district judges when a request to review a bail decision is received, and district judges must act by the next business day. Is that my understanding?
Well, there's two provisions. One is basically an appeal from a magistrate's decision to a district judge.
Okay.
And that's in one section. The other section is really a bail decision that's made that the prosecutor feels is an adequate or insufficient amount of bail will have an expedited appeal to the Court of Appeals.
Okay. And if the judge decides to modify a bail decision, the judge must issue a summons for the defendant to appear and give the defendant a reasonable opportunity to appear before issuing a warrant, an arrest warrant. Is that?
Yeah, and that would mean that if a magistrate had set bail at $1,000, it was posted, and then that was appealed to the district judge. The district judge said, no, that's not enough. You need $10,000 of bail in this case. Then the defendant would be given reasonable notice and an opportunity to post the additional amount of bail before they would be brought into custody.
And so there's some other key provisions that SB 9 includes, and that would be, and I think this has been mentioned several times, the standard of proof codifies that SB 9 again codifies clear and convincing evidence as the standard required to establish a firm belief or conviction in the truth of allegations used to justify detention or bail conditions. Is that being codified?
Mr. Walle, that's correct, except there is an amendment coming.
Okay.
I discussed this, I think, with Mr. Cook a moment ago on the exchange, to take the clear and convincing definition out of the bill.
Okay. Why would we do that?
Well, the consensus was that the clear and convincing standard is well developed in common law, in case law. It's used primarily in family law cases. And we felt like the consensus among those that were working on it was that we might create confusion if we further defined it in this particular statute.
What standard of proof would we be using?
Well, we would use the clear and convincing standard.
Okay.
And there's nothing
in practice, but not codified.
Well, no. It's in Senate. It's in clear and convincing is in SJR 5.
Okay.
It's another. And so what this was doing, instead of defining it, the standard in the Constitution, we were just defining it in statute. But as I say, the consensus was better that it's developed in common law. There was no need to further define it.
I understand that. And just again, to keep fleshing this out, if a defendant previously released on bail for a felony is charged with a new felony, SB 9 requires an electronic notice to be sent by the next business day to a designated individual in the county so that the court may consider revoking, modifying, or reevaluating the previous bail decision.
Yes.
I think that was touched upon by Representative Cook, is it my understanding?
I think we discussed that.
Okay. SB 9 mandates that bail organizations submit monthly reports to the Office of Court Administration detailing specific charge and bond information, including whether any bond forfeitures occurred. Is that my understanding?
Yeah, now this is the section that deals with these nonprofit organizations that take nonprofit money and provide funding for bonds for defendants.
Okay, and then I think we've mentioned on the record that doesn't happen.
Well,
there's dispute that it happens or not happens.
Well, there's no dispute that we do have these nonprofit organizations out there that do this. The dispute was over whether any taxpayer funds are going to these organizations, and
that's a good clarification. So we're just codifying what is already prohibited under current law. Is that my understanding?
Well, that was the last bill.
The last bill. Okay.
Yeah, the last bill.
Okay.
Now this bill is just kind of beefing up the reporting requirements. These groups are already required to report to the Office of Court Administration. Okay. And so this is just kind of giving a little more detailed information to OCA so they can evaluate whether the law is being followed.
And then to that point, the bill, as you mentioned, requires the OCA to report any suspected violations of this requirement to the county sheriff.
That's correct.
Okay. And then there's a section on victim notifications on bail compliance.
Yes.
And so SB 9 gives victims, guardians of victims, or close relatives of deceased victims the right to be informed of whether a defendant has complied with bail. Is that my understanding as well?
That's right. It's a victim's rights provision that allows, if a defendant has violated bail, I think everyone agrees that the victim should have a right to know, because it could affect the victim's safety. It could affect how, if the victim is still living, or the family of the deceased victim, it would be something they would want to know.
I think that's a good thing.
Yep.
Victims do need to be notified, so I have no issues with there. But again, just trying to flesh this out, SB 9 also expands the responsibilities of Texas courts and the OCA through new reporting requirements. Is that my understanding?
There's some new reporting requirements. Okay. I don't think they're onerous by any means.
No, not suggestion, but I just want to flesh that out too. Under SB 9, the public safety report system must now include additional data points and support broader access to prosecutors and district attorneys. Is that what this reporting requirement does?
Yes, we're trying to get full transparency in the criminal justice system so that everyone who's making these decisions has all the information they need to make a good decision.
Okay, and then additionally, SB 9 requires the the public safety reporting system to be configured to integrate county or municipal jail records and case management systems. That's logistically, that's important as well, because you have, I mean, obviously you have the Office of Court Administration, but I'm not sure what Harris County does different than Fort Bend or whatever.
Well, one of the problems is that the various counties have different software in place, and it's very difficult to get this information out there. But we have 254 counties, and we want to make sure that whatever county you're in, you get all the information that you need in order to make an informed decision if you're making any kind of bail decision.
Okay. To that point, the bill allows the Office of Court Administration to provide reimbursement grants to local governments for integration costs, but only if funds are appropriated by the legislature. Is that
exactly?
Okay.
And the counties are going to have to do some software updates to get this system fully implemented, and we would anticipate, I don't know if it's in the current budget, you would have more idea on that than I would, but I would anticipate at some point that we will help the counties out on that so that it doesn't become an unfunded mandate.
To that point, do you anticipate in negotiations, look, I serve on the Appropriations Committee, but do you have any knowledge about any reimbursements that some of the counties would have to incur globally? One for integration and the software integration, that's one, but also new staff, additional prosecutors, additional jailers, additional space in our jails. That we flush that out in the bill as well?
Yeah, I think that it's probably too early to know what the cost is going to be. I think it would probably be better to retroactively reimburse that at some point. We still don't have a good handle on that. As far as additional costs that these reforms will impose on counties, I would say this, that we were very careful in this bill. Sheriff Louderback deserves, I think, a lot of credit because he's managed a jail, he's run a jail, and he knows where to go to get the information. So we actually went to the detail of looking at each county in the state, their jail capacity, their available jail capacity. We looked at the number of cases that have been generated in the past in each of these classifications of felonies to see what population impact we might have. We basically designed the bill and the whole package to fit the capacity that we've got. And we're trying to be mindful of that. We don't want to have to go out and build new jails or make counties build new jails, but there may be additional cost on some of these to counties because there'll be...
The gentleman's time has expired.
Yeah, just what? I think I'm in
Mr.
order
Walle, for what purpose?
one extension of time.
Members, you've heard the motion. Is there objection? Chair is none so ordered.
Thank you, Mr. Speaker. Just to flush this out on the costs to local counties and the jails. And look, we run the largest jail system in the state at Harris County, and also commingles as the largest mental institution in the state. We prescribe millions of dollars probably of prescription drugs that some of these folks need. They need that medication. Was there any discussion with any of the counties on implementation of this? This is a monumental bill. And look, I'm going to support the bill. Let me just say that. But I do want to flush these things out so that Texans are aware of what we're about to do in a few minutes. Were any of the counties consulted?
Well, I know we did have
changes?
Testimony, I think, in the committee or shortly after that. We have had a number of counties contact us with suggestions as to how we could reduce the cost, and we've tried to follow those. I would say this, that most of the offenses and most of the defendants that are covered in this legislation are already going to be held in custody in jails. This is basically trying to ensure that those that slip between the cracks and are released because of a bad decision or or whatever, that we are able to keep those defendants incarcerated. So I don't think this is going to be a big increase in the number of inmates that we're housing in Texas, because most of these that fit into these categories are already there. We're just aiming for a few that are slipping through the cracks, and those, unfortunately, are the ones that can do a lot of damage to people. It can ruin people's lives, kill people, and ruin their lives.
No, I certainly agree with that sentiment. No argument on that point.
And I think to address your problem, I think, and I've talked to Senator Huffman about this, and I think very possibly when we come back next time, and we're going to have to look at helping some of the counties out on this, because we'll have a lot better data at that point to know if there is, how much additional cost there is. And there's no more function of government, in my opinion, more important than protecting our innocent citizens. I think we have to do that. And so we basically spend what we have to spend to protect our people. And so
I agree with that sentiment. We need to hold people accountable for the crimes they commit. But I also know that we do have a constitution. Folks do have a constitutional, it's the bedrock of our criminal judicial system. And we have to strike that balance. And so I understand the need to strike the balance in these bills in enumerating certain crimes like murder, terroristic threat, violations of certain conditions on bond, possession of firearms. I don't think you'll get any argument for many people, at least for me, I'm sorry, that folks that are repeat offenders should be held accountable and should have a shorter leash, I guess, if you want to call it, than being let out on bond while they're awaiting trial on other crimes. And so when they commit subsequent crimes, it's a problem. So I get that. Just again, I wanted to come back to the county threshold, the 200,000 and the magistrate issue. Is there any sentiment either on the Senate side, or at least from you that's carrying the bill on this side, that we could apply this bill statewide? Because I'm almost positive, I don't have any proof, but I'm almost positive that this would be an issue in other parts of the state as well, not just in Harris County.
Well, it's not an issue to the extent that it is in the larger counties. It's not just Harris County. I think Travis County's been a problem, Dallas County to some extent. And so that's where the problem has been. That's what we were trying to address. I would say this, Mr. Walle, I think that it is probably a good place to start at 200,000, and then next session, if we can reevaluate and see if that number needs to be raised or lowered or eliminated altogether. But it just seemed, like I say, it came from the Senate that way. We're trying to, avoid a conference committee on this so that we can finally get this done. And it seemed like there was a logical reason to keep it at 200,000 for two reasons.
You mentioned earlier that you're going to include an amendment that takes out clear and convincing. Well, you're already going to go to conference, I assume.
No,
by making changes. Or am I wrong in my assessment on that? If you're going to make change, you're already going to accept the amendment. You're going to change the bill, so you'd have to go to conference. I don't know. You tell me if I don't know my rule book correctly.
Well, we've been working with Senator Huffman and the Senate on this, and I think that I'm going to have an amendment that will have some cleanup language, including in a moment, including removal of clear and convincing. That amendment has been cleared with the Senate and with the governor's office. So we're hoping that the Senate will simply concur in the bill if we're fortunate enough to pass here.
Okay. Well, I appreciate your time and appreciate your work on it, and the folks that have worked on it, I know, have tried to put some constraints on this so that we're not, we're not in prison, we're not incarcerating folks or detaining folks without due process. So I appreciate your time.
Well, I appreciate you reading the bill in so much detail. Thanks.